This audio case is brought to you by Laudio. Woodward v. Comm'r, 2002. The United States District Court for the District of Massachusetts has certified the following question to this court. If a married man and woman arrange for sperm to be withdrawn from the husband for the purpose of artificially impregnating his wife, and the woman is impregnated with that sperm after the man, her husband, has died, will children resulting from such pregnancy enjoy the inheritance rights of natural children under Massachusetts law of intestate succession? We answer the certified question as follows. In certain limited circumstances, a child resulting from posthumous reproduction may enjoy the inheritance rights of issue under the Massachusetts intestacy statute. These limited circumstances exist where, as a threshold matter, the surviving parent or the child's other legal representative demonstrates a genetic relationship between the child and the decedent. The survivor or representative must then establish both that the decedent affirmatively consented to posthumous conception and to the support of any resulting child. Even where such circumstances exist, time limitations may preclude commencing a claim for succession rights on behalf of a posthumously conceived child. Because the government has conceded that the timeliness of the wife's paternity action under our intestacy law is irrelevant to her federal appeal, we do not address that question today. The United States District Court judge has not asked us to determine whether the circumstances giving rise to succession rights for posthumously conceived children apply here. In addition, she has removed from our consideration the question whether the paternity judgment obtained by the wife in this case was valid. We answer only the certified question. The undisputed facts and relevant procedural history are as follows. In January 1993, about 3.5 years after they were married, Lauren Woodward and Warren Woodward were informed that the husband had leukemia. At the time, the couple was childless. Advised that the husband's leukemia treatment might leave him sterile, the Woodwards arranged for a quantity of the husband's semen to be medically withdrawn and preserved, in a process commonly known as sperm banking. The husband then underwent a bone marrow transplant. The treatment was not successful. The husband died in October 1993, and the wife was appointed administratrix of his estate. In October 1995, the wife gave birth to twin girls. The children were conceived through artificial insemination using the husband's preserved semen. In January 1996, the wife applied for 2 forms of Social Security survivor benefits: child's benefits under United States Code Title 42, Section 402D1, and mother's benefits under United States Code Title 42, Section 402G1. The Social Security Administration, SSA, rejected the wife's claims on the ground that she had not established the twins were the husband's children within the meaning of the Act. In February 1996, as she pursued a series of appeals from the SSA decision, the wife filed a complaint for correction of birth record in the Probate and Family Court against the clerk of the City of Beverly, seeking to add her deceased husband as the father on the twins' birth certificates. In October 1996, a judge in the Probate and Family Court entered a judgment of paternity and an order to amend both certificates declaring the deceased husband to be the children's father. In his judgment of paternity, the probate court judge did not make findings of fact, other than to state that he, quote, accepts the stipulations of voluntary acknowledgement of parentage of the children executed by the wife as mother, and the wife, administratrix of the estate of the husband, for father, end quote. The wife presented the judgment of paternity and the amended birth certificates to the SSA, but the agency remained unpersuaded. A United States administrative law judge, hearing the wife's claims de novo, concluded, among other things, that the children did not qualify for benefits because they, quote, are not entitled to inherit from the husband under the Massachusetts intestacy and paternity laws, end quote. The Appeals Council of the SSA affirmed the administrative law judge's decision, which thus became the Commissioner's final decision for purposes of judicial review. The wife appealed to the United States District Court for the District of Massachusetts, seeking a declaratory judgment to reverse the commissioner's ruling. The United States District Court judge certified the above question to this court because, quote, the parties agree that a determination of these children's rights under the law of Massachusetts is dispositive of the case and no directly applicable Massachusetts precedent exists, end quote. Section A. We have been asked to determine the inheritance rights under Massachusetts law of children conceived from the gametes of a deceased individual and his or her surviving spouse. We have not previously been asked to consider whether our intestacy statute accords inheritance rights to posthumously conceived genetic children, nor has any American court of last resort considered, in a published opinion, the question of posthumously conceived genetic children's inheritance rights under other states' intestacy laws. This case presents a narrow set of circumstances, yet the issue it raises are far-reaching. Because the law regarding the rights of posthumously conceived children is unsettled, the certified question is understandably broad. Moreover, the parties have articulated extreme positions. The wife's principal argument is that, by virtue of their genetic connection with the decedent, posthumously conceived children must always be permitted to enjoy the inheritance rights of the deceased parent's children under our law of intestate succession. The government's principal argument is that because posthumously conceived children are not in being as of the date of the parent's death, they are always barred from enjoying such inheritance rights. Neither party's position is tenable. In this developing and relatively uncharted area of human relations, bright-line rules are not favored unless the applicable statute requires them. The Massachusetts intestacy statute does not. Neither the statute's posthumous children provision nor any other provision of our intestacy law limits the class of posthumous children to those in utero at the time of the decedent's death. On the other hand, with the act of procreation now separated from coitus, posthumous reproduction can occur under a variety of conditions that may conflict with the purposes of intestacy law and implicate other firmly established state and individual interests. We look to our intestacy law to resolve these tensions. Section B. We begin our analysis with an overview of Massachusetts intestacy law. In our Commonwealth, the devolution of real and personal property in intestacy is neither a natural nor a constitutional right. It is a privilege conferred by statute. Our intestacy statute, quote, excludes all rules of law which might otherwise be operative. It has impliedly repealed all pre-existing statutes and supersedes the common law. End quote. Section 1 of the intestacy statute directs that, if a decedent leaves issue, such issue will inherit a fixed portion of his real and personal property, subject to debts and expenses, the rights of the surviving spouse, and other statutory payments not relevant here. To answer the certified question, then, we must first determine whether the twins are the issue of the husband. The intestacy statute does not define issue. However, in the context of intestacy, the term issue means all lineal genetic descendants and now includes both marital and non-marital descendants. The term descendants has long been held to mean persons who by consanguinity trace their lineage to the designated ancestor. Turning to issue who are the non-marital children of an intestate, the intestacy statute treats different classes of non-marital children differently based on the presumed ease of establishing their consanguinity with the deceased parent. A non-marital child is presumptively the child of his or her mother and is entitled by virtue of this presumption to enjoy inheritance rights as her issue. However, to enjoy inheritance rights as the issue of a deceased father, a non-marital child, in the absence of the father's acknowledgement of paternity or marriage to the mother, must obtain a judicial determination that he or she is the father's child. The general purpose of such a specific adjudication requirement is to ensure that wealth passes from and to the actual family. We held, at a time when the means for establishing the paternity of a child were less certain than they are today, that such disparate treatment between the mother and the father of a child advanced the legislature's interests in preventing fraudulent claims against the estate and in administering estates in an orderly fashion. The posthumous children provision of the intestacy statute is yet another expression of the legislature's intent to preserve wealth for consanguineous descendants. That section provides that posthumous children shall be considered as living at the death of their parent. The legislature, however, has left the term posthumous children undefined. The Massachusetts intestacy statute originally made no provision for afterborn children. Then, in Hall v. Hancock, 1834, in the context of a will contest, this court held that a child who was presumptively in utero as of the date of the decedent's death was a child in being as of the date of the decedent's death, in all cases where it will be for the benefit of such child to be so considered. 2 years later, the legislature enacted the posthumous children provision of the intestacy statute, bringing that devolution mechanism into conformity with our decision concerning wills. Despite numerous later amendments to our intestacy laws, the posthumous children provision has remained essentially unchanged for 165 years. The Massachusetts intestacy statute thus does not contain an express affirmative requirement that posthumous children must be in existence as of the date of the decedent's death. The legislature could surely have enacted such a provision had it desired to do so. We must therefore determine whether, under our intestacy law, there is any reason that children conceived after the decedent's death, who are the decedent's direct genetic descendants, that is, children who by consanguinity trace their lineage to the designated ancestor, may not enjoy the same succession rights as children conceived before the decedent's death, who are the decedent's direct genetic descendants. To answer that question, we consider whether and to what extent such children may take as intestate heirs of the deceased genetic parent consistent with the purposes of the intestacy law, and not by any assumptions of the common law. In the absence of express legislative directives, we construe the legislature's purposes from statutory indicia in judicial decisions in a manner that advances the purposes of the intestacy law. The question whether posthumously conceived genetic children may enjoy inheritance rights under the intestacy statute implicates three powerful state interests: the best interest of the children, the state's interest in the orderly administration of estates, and the reproductive rights of the genetic parent. Our task is to balance and harmonize these interests to effect the legislature's overall purposes. First and foremost, we consider the overriding legislative concern to promote the best interests of children. The protection of minor children, most especially those who may be stigmatized by their illegitimate status, has been a hallmark of legislative action and of the jurisprudence of this court. Repeatedly, forcefully, and unequivocally, the legislature has expressed its will that all children be entitled to the same rights and protections of the law, regardless of the accidents of their birth. Among the many rights and protections vouchsafed to all children are rights to financial support from their parents and their parents' estates. We also consider that some of the assistive reproductive technologies that make posthumous reproduction possible have been widely known and practiced for several decades. In that time, the legislature has not acted to narrow the broad statutory class of posthumous children to restrict posthumously conceived children from taking in intestacy. Moreover, the legislature has in great measure affirmatively supported the assistive reproductive technologies that are the only means by which these children can come into being. We do not impute to the legislature the inherently irrational conclusion that assistive reproductive technologies are to be encouraged while a class of children who are the fruit of that technology are to have fewer rights and protections than other children. In short, we cannot, absent express legislative directive, accept the Commissioner's position that the historical context of annotated Massachusetts law, Chapter 190, Section 8, dictates as a matter of law that all posthumously conceived children are automatically barred from taking under the deceased donor parent's intestate estate. We have consistently construed statutes to effectuate the legislature's overriding purposes to promote the welfare of all children, notwithstanding restrictive common law rules to the contrary. Posthumously conceived children may not come into the world the way the majority of children do, but they are children nonetheless. We may assume that the legislature intended that such children be entitled, insofar as possible, to the same rights and protections of the law as children conceived before death. However, in the context of our intestacy laws, the best interests of the posthumously conceived child, while of great importance, are not in themselves conclusive. They must be balanced against other important state interests, not the least of which is the protection of children who are alive or conceived before the intestate parent's death. In an era in which serial marriages, serial families, and blended families are not uncommon, according succession rights under our intestacy laws to posthumously conceived children may, in a given case, have the potential to pit child against child and family against family. Any inheritance rights of posthumously conceived children will reduce the intestate share available to children born prior to the decedent's death. Such considerations, among others, lead us to examine a second important legislative purpose: to provide certainty to heirs and creditors by effecting the orderly, prompt, and accurate administration of intestate estates. The intestacy statute furthers the legislature's administrative goals in two principal ways. 1. By requiring certainty of filiation between the decedent and his issue, and 2. By establishing limitation periods for the commencement of claims against the intestate estate. In answering the certified question, we must consider each of these requirements of the intestacy statute in turn. First, as we have discussed, our intestacy law mandates that, absent the father's acknowledgement of paternity or marriage to the mother, a non-marital child must obtain a judicial determination of paternity as a prerequisite to succeeding to a portion of the father's intestate estate. Both the United States Supreme Court and this court have long recognized that the state's strong interest in preventing fraudulent claims justifies certain disparate classifications among non-marital children based on the relative difficulty of accurately determining a child's direct lineal ancestor. Because death ends a marriage, posthumously conceived children are always non-marital children. And because the parentage of such children can be neither acknowledged nor adjudicated prior to the decedent's death, it follows that, under the intestacy statute, posthumously conceived children must obtain a judgment of paternity as a necessary prerequisite to enjoying inheritance rights in the estate of the deceased genetic father. Although modern reproductive technologies will increase the possibility of disputed paternity claims, sophisticated modern testing techniques now make the determination of genetic paternity accurate and reliable. Posthumous maternity is as uncertain until judicially established as is posthumous paternity, and neither more nor less difficult to prove. A construction of the intestacy statute that would impose greater burdens on children posthumously conceived from their father's gametes than on children posthumously conceived from their mother's gametes would run afoul of our state and federal constitutions, for such classifications would serve no rational state interest. We now turn to the second way in which the legislature has met its administrative goals: the establishment of a limitations period for bringing paternity claims against the intestate estate. Our discussion of this important goal, however, is necessarily circumscribed by the procedural posture of this case and by the terms of the certified question. The certification record discloses that, after one unsuccessful insemination attempt, the wife conceived using her deceased husband's sperm approximately 16 months after his death. The children were born approximately 2 years after the husband's death, and the paternity action, in the form of a complaint for correction of birth record, was filed approximately 4 months after the children's birth. Both the SSA and the administrative law judge concluded that the wife and the children were not entitled to Social Security survivor benefits because, among other things, the paternity actions were not brought within the 1-year period for commencing paternity claims mandated by the intestacy statute. However, in his brief to the court, the commissioner represented that he had informed the United States District Court judge that the wife had been advised that she need not address the timeliness issue on appeal in light of a change in federal regulations. Specifically, the SSA has amended its regulations to read, quote, "We will not apply any state inheritance law requirement that an action to establish paternity must be taken within a specified period of time measured from the worker's death or the child's birth, or that an action to establish paternity must have been started or completed before the worker's death." End quote. We understand the commissioner's representation to be a concession that the timeliness of the wife's Massachusetts paternity actions is not relevant to the federal law question of whether the wife's children will be considered the husband's natural children for Social Security benefits purposes, and that therefore whatever we say on this issue has no bearing on the wife's federal action. We also note that the certified question does not specifically address a limitations matter, and that, in their briefs to this court, the parties refer to the limitations questions only peripherally. Nevertheless, the limitations question is inextricably tied to consideration of the intestacy statute's administrative goals. In the case of posthumously conceived children, the application of the 1-year limitations period of annotated Massachusetts law, Chapter 190, Section 7, is not clear. It may pose significant burdens on the surviving parent and consequently on the child. It requires, in effect, that the survivor make a decision to bear children while in the freshness of grieving. It also requires that attempts at conception succeed quickly. Because the resolution of the time constraints question is not required here, it must await the appropriate case, should one arise. Finally, the question certifies to us implicates a third important state interest, to honor the reproductive choices of individuals. We need not address the wife's argument that her reproductive rights would be infringed by denying succession rights to her children under our intestacy law. Nothing in the record even remotely suggests that she was prevented by the state from choosing to conceive her children using her deceased husband's semen. The husband's reproductive rights are a more complicated matter. In AZ versus BZ 2000, we considered certain issues surrounding the disposition of frozen pre-embryos. A woman sought to enforce written agreements between herself and her former husband. The wife argued that these agreements permitted her to implant frozen pre-embryos created with the couple's gametes during the marriage, even in the event of their divorce. We declined to enforce the agreements. Persuasive to us, among other factors, was the lack of credible evidence of the husband's true intention regarding the disposition of the frozen pre-embryos and the changed family circumstance resulting from the couple's divorce. Recognizing that our laws strongly affirm the value of bodily and reproductive integrity, we held that forced procreation is not an area amenable to judicial enforcement. In short, AZ versus BZ recognize that individuals have a protected right to control the use of their gametes. Consonant with the principles identified in AZ versus BZ, a decedent's silence or his equivocal indications of a desire to parent posthumously ought not to be construed as consent. The prospective donor parent must clearly and unequivocally consent not only to posthumous reproduction, but also to the support of any resulting child. After the donor parent's death, the burden rests with the surviving parent or the posthumously conceived child's other legal representative to prove the deceased genetic parent's affirmative consent to both requirements for posthumous parentage, posthumous reproduction, and the support of any resulting child. This twofold consent requirement arises from the nature of alternative reproduction itself. It will not always be the case that the person elects to have his or her gametes medically preserved to create issue posthumously. A man, for example, may preserve his semen for myriad reasons, including, among others, to reproduce after recovery from medical treatment, to reproduce after an event that leaves him sterile, or to reproduce when his spouse has a genetic disorder or otherwise cannot have or safely bear children. That a man has medically preserved his gametes for use by his spouse thus may indicate only that he wished to reproduce after some contingency while he was alive, and not that he consented to the different circumstance of creating a child after his death. Uncertainty as to consent may be compounded by the fact that medically preserved semen can remain viable for up to 10 years after it was first extracted, long after the original decision to preserve the semen has passed, and when such changed circumstances as divorce, remarriage, and a second family may have intervened. Such circumstances demonstrate the inadequacy of a rule that would make the mere genetic tie of the decedent to any posthumously conceived child, or the decedent's mere election to preserve gametes, sufficient to bind his intestate estate for the benefit of any posthumously conceived child. Without evidence that the deceased intestate parent affirmatively consented, 1. to the posthumous reproduction, and 2. to support any resulting child, a court cannot be assured that the intestacy statute's goal of fraud prevention is satisfied. As expressed in our intestacy and paternity laws, sound public policy dictates the requirements we have outlined above. Legal parentage imposes substantial obligations on adults for the welfare of children. Where two adults engage in the act of sexual intercourse, it is a matter of common sense and logic, expressed in well-established law, to charge them with parental responsibilities for the child who is the natural, even if unintended, consequences of their actions. Where conception results from a third-party medical procedure using a deceased person's gametes, it is entirely consistent with our laws on children, parentage, and reproductive freedom to place the burden on the surviving parent or the posthumously conceived child's other legal representative to demonstrate the genetic relationship of the child to the decedent, and that the intestate consented both to reproduce posthumously and to support any resulting child. Section C. The certified question does not require us to specify what proof would be sufficient to establish a successful claim under our intestacy law on behalf of a posthumously conceived child. Nor have we been asked to determine whether the wife has met her burden of proof. The record reveals that the administrative law judge repeatedly requested that the wife provide objective corroboration of her claim that the husband consented to father children after his death. The administrative law judge's opinion indicates that he was willing to consider, quote, additional declarations or written statements from the decedent's family, the wife's family, financial records, or records from the Fertility Institute that demonstrate any acknowledgement of the children made by the husband, end quote. Perhaps because the law was unsettled at the time, the wife's counsel took the position that the paternity judgment and the birth certificates were sufficient and that no further evidence was required. In the wife's probate court action, however, the judge held the husband to be the father of the children, but did not make any specific findings to support that determination. Nor did he determine whether the husband intended to support the wife's children. Moreover, although a birth certificate is prima facie evidence of the facts recorded therein, under our laws, genetic and legal parentage are not always coterminous. It is undisputed in this case that the husband is the genetic father of the wife's children. However, for the reasons stated above, that fact in itself cannot be sufficient to establish that the husband is the children's legal father for purposes of the devolution and distribution of his intestate property. In the United States District Court, the wife may come forward with other evidence as to her husband's consent to posthumously conceive children. She may come forward with evidence of his consent to support such children. We do not speculate as to the sufficiency of evidence she may submit at trial. Section D. We feel constrained to comment on the judgment of paternity and the issuance of the amended birth certificates. The probate and family court judge should not have entered the paternity judgment or ordered the husband's name added to the birth certificates on the record the mother presented. The mother sought to establish her deceased husband's paternity of the twins by bringing a complaint to amend birth records against the clerk of the city of Beverly, who, according to the judgment of paternity, did not object to the action. Where an estate is at issue, which will always be the case where a parent is deceased, notice of the action to establish legal parentage should be given to every other interested party, including the potential heirs who would have taken but for the posthumous creation of the children. The record also discloses that the wife sought to bind the husband's estate for the benefit of her posthumously conceived children by filing stipulations of voluntary acknowledgement of parentage executed by herself as mother and by herself as administratrix of the husband's estate. The probate and family court judge should not have considered these stipulations, much less grounded his paternity judgment on them. Neither the statutory powers granted to administrators nor the Massachusetts intestacy and paternity laws permit such procedures to establish paternity. For the second time this term, we have been confronted with novel questions involving the rights of children born from assistive reproductive technologies. As these technologies advance, the number of children they produce will continue to multiply. So too will the complex moral, legal, social, and ethical questions that surround their birth. The questions present in this case cry out for lengthy, careful examination outside of the adversary process, which can only address the specific circumstances of each controversy that presents itself. They demand a comprehensive response reflecting the considered will of the people. In absence of statutory directives, we have answered the certified question by identifying and harmonizing the important state interests implicated therein in a manner that advances the legislature's overall purposes. In so doing, we conclude that limited circumstances may exist, consistent with the mandates of our legislature, in which posthumously conceived children may enjoy the inheritance rights of issue under our intestacy law. These limited circumstances exist where, as a threshold matter, the surviving parent or the child's other legal representative demonstrates a genetic relationship between the child and the decedent. The survivor or representative must then establish both that the decedent affirmatively consented to posthumous conception and to the support of any resulting child. Even where such circumstances exist, time limitations may preclude commencing a claim for succession rights on behalf of a posthumously conceived child. In any action brought to establish such inheritance rights, notice must be given to all interested parties. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook, and subscribe to our YouTube channel.